Let us start solving the questions of the Indian Evidence Act. First of all, read the quotation. अपनी समस्या से भागना एक ऐसी दौड़ है जिसमें आप कभी जीत नहीं सकती. Yes, if you do not face your problem, then you never succeed. So try your best to face the problem that is relating to you. Yes. In election petition, the burden of proof lies on. In election petition, burden of proof lies on the person who contested election. It means if A and B are contesting person in an election, are they liable? Next, the person who challenged the election, if A is declared as a winner of the election, then there is no need of A. There is no need to challenge the election by A. But if B arises an objection, then the burden of proof shall lie upon B. It means the person who challenges the election, that person shall be liable. So here the answer of the question shall be B. The person who challenged the election. It means A in an election is declared as a winner, but B challenges that in election a corruption is committed. Election is not fair. Then the burden of proof shall lie upon B to prove the corruption. To prove the corruption, proving the corruption, burden of proof shall lie upon B. So the correct answer, the question is B. B is the correct answer. Yes. The burden of proof in a suit of proceeding lies upon that person who would fail if no evidence at all were given on either side. If on either side no evidence is given, then the person shall fail. Answer, it means according to section 102, it is said that if in a suit, if a person does not, if a person, a party of the suit shall fail if no evidences are given on either side before the court. The person who fails burden of proof shall lie upon that person. It is mentioned in the section 102 of Indian Evidence Act. So the correct answer of the question shall be C. C is the correct answer of the question 2. Okay. Burden of introducing evidence under section 102 of the Evidence Act. Burden of proof in introducing evidence shifts at times, never shifts continuously. Yes, shifts from party to other party, then other party to first party. It always shifts. So the correct answer of the question C. The burden of proof in a suit or proceeding lies on whom? Among the following. On whom? The defense, the prosecution, no. The person who, the one who alleges, no. The one who would fail if no evidences at all were given on either side, according 102, section 102. According to section 102, it has been mentioned, it has been propounded that if on either side no evidences are given, the person would fail. Then the burden of the proof shall lie on that person. Okay? So the correct answer of the question D. Next. A suit B for land of which B is in possession and which A asserts was left to A by the will of C. Okay? B's father, to whom the burden of proof will lie. To whom the burden of proof will lie. Who shall be liable to giving the proof? Because the problem is A is a person. A is a person who arises an objection over a land. And this land, the land was B's possession. B holds the possession over the land. A says that this property is obtained to A by a will. Whose will? B's father's will. B's father by a will gives the property to A, but B holds the possession over the property. A challenge that the property should be of A. If no evidences are given on either side before the court, A shall defeat. According to section 102, the person who would defeat shall be liable to produce the burden of, it means the burden of proof shall lie upon that person. It means according to section 102, burden of proof shall lie upon A. So the correct answer of the question is A. A prosecutes B for theft, okay, and wishes the court to believe that B admitted the theft to C. If no evidence, it means if any statement is given before the court and the person giving the statement wants to believe that statement by the court, then the burden of proof shall lie upon the person who giving the statement before the court. So A have to prove the admission. Burden of proof shall lie upon A, not C. Why? Because A prosecutes B. A prosecutes B for theft and wishes the court. Who wishes? Mr. A wishes the court to believe that B admitted the theft to C. Here, Mr. A wishes the court. According to section 103, liability shall be lie upon A. So the correct answer of the question is A. Okay. A wishes to prove dying declaration by B. Okay. A must prove B's death. Yes. Under section 104. If any special knowledge is to be proved by a person, the burden of proof shall lie upon the person who has such knowledge. So, A wishes to prove dying declaration by B. A must prove B's death first of all, because dying declaration is to be proved when the person's death is proved first of all. If death of person is proved, then dying declaration is to be proved. So the firstly, death of the person should be proved. So under section 104, if a person wishes to prove dying declaration, then that B has made a dying declaration before C. The first of all, A has to prove B's death. First of all, A has to prove B's death, that B has died. Then dying declaration of B shall be proved. So burden of proof shall lie upon A, and firstly A has to prove that B has died according to section 104. Okay. Next, section 105 of Evidence Act is intended to apply to which of the following? Criminal trial, civil suit, both or neither? Yes. Section 105 is relating to the exception. If any person wants to take the benefit of exception from section 76 to 106, then the person or burden of proof shall lie upon the person who wants to take the benefit of the exception. It is propounded in the section 105 of Indian Evidence Act. So here another question. What? Section 105 of Evidence Act is intended to apply to which of the following? Note it down. It is a procedural law. Indian Evidence Act is undoubtedly a procedural law and relating to criminal, and the evidences, what are the evidences shall be produced not only in criminal but civil also. But section 105 is apply only and only in criminal cases. So here the option A is the correct answer, not civil case, not civil trial. Civil suit in civil suit it shall not be applied. Only criminal trials it shall be applied. So the correct answer of the question 8 is A. Okay. The burden of proving the existence of circumstances bringing the case within the general exception in Indian Penal Code. Yes, I have told you that the accused person, burden of proof shall lie upon the accused who wants to take the benefit of exception. So the liability of burden of proof shall lie upon the person who is accused. So here answer of the question shall be D. D is the correct answer. D is the correct answer of the question. Next, the burden of proving that the case of an accused comes within general exception of IPC is on accused. Okay. Yes, accused, not prosecution. The burden of proving that the case of an accused comes with general exception. General exception in general exception, burden of proof shall lie upon the person, on the accused. Okay. A is accused of murder. His pleader plead that by reason of unsoundness of mind, he did not know the nature of the act. In such case, burden of proof shall lie upon the accused, because under section 105, it is clearly mentioned that if the accused wants to take the advantage of the exception, the burden of proof shall lie upon him, according to section 105. So, burden unsoundness of proof will lie upon accused. Yes, burden of unsoundness of proof will be upon prosecution. No, prosecution should prove the accused was sound mind. Unsoundness until revoked should be presumed. Unsoundness until revoked, no. Burden of proof will be upon accused. Here the term should be accused, because unsoundness of mind should be proved that he was of unsoundness of mind at that time when he was committing that offense. He was of unsoundness of mind at that time when he was committing the offense. The burden of proof will lie upon the pleader or the accused. Okay, so A here the term accused is not written, not printed. Here the term should be accused. Okay, A. Next, A accused of murder alleges that by grave and sudden provocation he was deprived of the power of self-control. Okay, B denies this fact The burden of proof to whom lie? A. A shall lie. So here the burden of proof must shared by A and B. No. The burden of proof is on B. No. The burden of proof is on prosecution. No. The burden of proof is on A. Yes. D. Because if a person wants to take any advantage of the exception, then the burden of proof shall lie upon that person, that he was at that time when he commits the offense was under this exception. So liability shall lie on that person. It means accused who wants to take the benefit of the exception. So the correct answer D of the question. An accused of murder alleges that by grave and sudden provocation he was deprived of the self-control under Indian Evidence Act. Yes. Burden of proof shall lie upon the accused. Okay. B is the correct answer. Repeated question. Which of the following sections of Indian Evidence Act deal with the burden of proving fact, especially with knowledge? Especially with knowledge is relating to section 106. Res ipsa locator. Res ipsa locator is connected with section 106. So the correct answer of question is E. The principle is stated in section 106 that is relating to knowledge also of Indian Evidence Act is an application of principle of res ipsa locator. Yes, it is correct answer. B is the correct answer of the question. Okay. When any facts is especially within the knowledge of accused, the burden of proving that fact is upon. When any facts is especially within the knowledge of the accused, okay, the burden of proving that fact is upon the person whom accused, prosecution, either accused or prosecution, none of the above. Actually here the answer should be when any facts is especially within the knowledge of the accused. Okay, accused, the term is used. When any fact is especially within the knowledge of the accused, the burden of proving that fact is upon the accused. Why? If any special knowledge, with the knowledge of any person, the burden of proof shall lie upon that person who has the special knowledge about the fact. The person who has special knowledge about the fact, burden of proof shall lie upon that person. In the question, special knowledge, who has? Accused has. So the burden of proof shall lie upon the accused. So the correct answer of the question A. A is the correct answer. Next. A school teacher during school hours was found in a restricted military area. Okay. He defended himself by stating that he was authorized to enter in restricted area is upon the home teacher, principal. Why? Because he has to explain why he was authorized. If he say that I am authorized to enter into this military area, this restricted area, why we are entitled? The burden of proof shall lie upon me. Here the principal claims that I am authorized, So the liability, so the burden of proof shall lie upon the person. It means principal. So the correct answer of the question, the authority that regulates entry, no. The security guard, no. The person who was found in the restricted area, yes. The officer who found, the person who was found, not found, who was found in the restricted area, who was found, principal. Principal was found. So the liability or burden of proof shall lie upon that person, that is principal. C is the correct answer of the question. C is the correct answer of the question. Okay. Yes, thanking you a lot of. Okay, thank you. That's all.